Our last case for today is Michigan Republican Party versus Donahue. Good morning. This is a 15-minute mini oral argument on the application. You both have 2 minutes of a free fire zone, which you may waive. Mr. Avers, you have 2 minutes of, you may reserve rebuttal time, but if you do so, we ask that you keep track of it yourself. And you may begin whenever you're ready.
Good morning.
Morning.
Robert Avers, on behalf of the Appellants, Michigan Republican Party and Republican National Committee. This court's decision in Lansing schools is clear, it's understandable, and is consistent with Michigan's prudential standing doctrine. Issued 15 years ago, it's settled law. Nonetheless, the trial court here failed to apply Lansing schools when it found that these plaintiffs lack standing. And then the Court of Appeals misapplied Lansing School when it affirmed that decision. While there is no express cause of action, we've briefed extensively why we believe that the Michigan Republican Party and the Republican National Committee have standing under the other 3 prongs of Lansing schools. And so I'm happy to take your questions.
Can you answer, if we agree with you and say that the lower courts were wrong and that you do have standing and you're back in the trial court, what relief can you get?
At this point in time? Well, so the Court of Appeals decision, to answer your question, they did find, the majority found that the case was moot, but it was capable of repetition, yet evading judicial review.
So the standing issue, yes, I mean, the next election, or if there's a discrepancy or a challenge, it can resolve the fact that your clients have standing. Can you get any relief for the alleged disparity in poll watchers from the 2022 election?
At this point in time, I'm not aware of any. I'm not aware of any relief, Your Honor.
Okay.
But I will.
And is there also, my understanding, there is, under the Court of Appeals opinion as it stands, the local county chair could initiate suit.
I actually disagree with that.
But
That's true. I mean, that is their conclusion. But
hasn't that occurred in other cases?
It
gets filed by the local county chair as opposed to the state or the national?
It occurred in one case, but only for the sake of complying with the
Court of Appeals
rule.
opinion.
And by memory, both the Michigan Republican Party and the Republican National Committees were also parties there.
Are they, they're frequently aligned interests, right?
Well, the definition of major political party under Michigan law doesn't say the 527 committee that's housed here in Michigan. It's the Republican Party. And, there has to be someone to bring the lawsuit, right? So oftentimes the two are coupled, and I think you often see the same on the other side of the aisle as well.
Is there a difference between state parties and national parties?
In what way?
For purposes of your standing analysis, would it make a difference?
In this case, I don't think it does, for several reasons. I think the easy one would be the injury. The RNC and the Michigan Republican Party both work together to recruit workers. They put their time and expense into that effort, and unfortunately those efforts fell by the wayside, and so they were both harmed in that regard. That's a harm that's different than one experienced by the citizenry at large, and so they would satisfy that.
Do they work with the county to do that same, the county party to do that same action?
The county?
To recruit poll watchers? The national, the state, and the county chair work together to put the
Are you asking could they or did they?
Could they, I guess?
If you had a functioning county party, I suppose that they could. But then we get into the interests of the state party versus the county party, right?
Okay.
And so I think, and that's, that's where it gets a little tricky with the county chair, because the county chair doesn't have, the state parties have a statewide interest in administering our elections. There's 5,000 precincts across the state. Every single one of those precincts has to have an election worker, an election inspector, from both the Republican Party and the Democrat Party at all times, from the time the poll opens until the time the poll closes, all day. They have to be there to close, to do the precinct canvass. And so that's a fairly large undertaking at the end of the day. I just don't see how the county chair has an interest. Like, it would seem to me that their interest in that process, since they don't have a role, right? It doesn't say that let's see, how do I explain this? The county chair is a step removed from the role of actually administrating the election. And I think you see that in section 674.3, subsection 3, where the legislature actually gave the chair 3 things that they can do in this process, right? They can challenge the qualifications of an election inspector, they can challenge the partisan bona fides of an election inspector, or they can challenge whether there's a valid declaration of partisan affiliation in the application. Now, that third one's interesting because, just one moment.
I don't want to take you off your point, but while you're looking for it, let me ask you this. If we were to agree with you, is it possible that any entity could acquire standing if they had spent, enough time or money and resources combating an alleged violation of statute?
That's the tricky part, right? And that's where we get into having an interest that's sufficient to ensure zealous and, I can't remember the other adjective, advocacy. And I think that's a case-by-case scenario. I actually think that risk is lower in the context, though, of a declaratory judgment, because you have this interplay between an actual controversy. Like, there has to actually be a disagreement, right? Like in this case, the board has a different view of what its duties are under Section 674 than what the Republican Party does. And so at the end of the day, there is a disagreement there between the two of them. And obviously both sides have an interest to take it to the end, because here we are. So I guess to answer your question, I think that's where a court has to ratchet down on whether they have that interest that's enough to ensure advocacy under Lansing schools.
And we obviously had some amicus briefs. You had a array of support for your position, so
Yeah.
I guess well done on that. Many of them advocated for the notion of injury being resources expended, I agree with you that 2605 is, provides a different avenue. Specifically, it, sharpens the issues raised by an interested party, the adverse process.
Right.
So, do you agree with that position?
I'm sorry, with what am I agreeing just before
The position that financial resources expended is enough, or you're saying it depends?
I think in this case it's enough. I mean, in this case, if you look at the record, the Republican Party set out on, they put forth actually a statewide effort in several jurisdictions to try to get more of their people involved in administering the election. They were working with the city of Flint, I think as far back as May of that year. I think it was about 5 months worth of back and forth with the clerk's office. It's a lot of time, energy, staff. So in this instance, I would say yes, that's sufficient.
So what would you say is the limiting principle then? You're saying that is a tricky question, right? Are we opening this up too wide and you're like, but we're safe here in your case. What's the limiting principle of why that works in your case, but because we would have to articulate what the limiting principle is.
Well, I think on the opposite end of the pole, you have the White v. Highland Park case, where you have I assume you're familiar with that case, but that would be the case where an ordinary citizen, general member of the public, sought a writ of mandamus to have more election workers appointed, but that person didn't even live in the community that that they were seeking more election inspectors for. Doesn't appear from the court's opinion that they had any affiliation with the party, and there weren't even any more applicants from the party for which there was a disparity. So unfortunately, I don't have a limiting principle for you, but I do see two sort of opposite ends of the
Right,
spectrum.
if we agree with you that that's on the outer edge, that doesn't help us answer where the line is closer to. You're still on the right side of it, and we know that white is on the outside of it, but where?
And I guess, excuse me for being naive, but I wasn't aware that there was like a ripple in Michigan's case law that like was causing that issue working its way up in the appellate system. I mean, to my mind, this is an error. This is just a reversible error from the Court of Appeals.
Okay.
So if I may, I do want to just,
Well, let me just ask you, if we were to agree with you and say they're standing to seek a deck action to meet the requirements under MCR 2605, does that end it, and then you just wait for the next election, or is there something to do? Is there anything to remand? Is there?
well, not in this case, but I do believe that the court would also need to reverse the last paragraph of White v. Highland Park, of the case, the Court of Appeals decision in White v. Highland Park,
Okay.
which in dicta goes on to say that Section 674-2, that county chairs have the exclusive authority to enforce that provision, which the part
Well,
of the
but
parties agree.
if we're agreeing with you that you have standing, doesn't that do the trick?
I believe it does, yes. I guess I'm just pointing out that
Okay.
that seems to have caused some level of confusion among the lower courts, that last paragraph in White v. Highland Park. I just want to make one more point, as my time is soon to run out. So county chairs, they can challenge those three criteria, right? The last one being that you have to have a declaration of partisan affiliation in your application. If you don't have such a declaration, you literally cannot serve as an election inspector. I recently learned this myself. It's MCL 168.677.
Why does this matter?
I'm going to get there
Okay,
in a
yeah.
minute, yeah.
Yes,
So,
I was looking at that
well,
too.
it matters because if you look at pages 81A through 109A of our appendix, you will see that there were no less than 10 independent election inspectors who were appointed to serve as inspectors in this case. And the Republican county chair did not challenge, obviously, neither did the Democrat county chair, challenge any of those individuals, despite the fact that subsection 674.3 expressly gives them the right to do so. And so, to my mind, if in this instance, where they're not even challenging the things that the legislature expressly gave you the authority to challenge, I don't think that the idea that we're going to entrust them with protecting the Republican Party's interests, when those interests are different, it's impractical, and it's also inconsistent with this case decision in Allstate v. Hayes, right? So in Allstate v. Hayes, you have an insurance company on one side of the V, and on the other side of the V, you have an insured and an injured party. And I guess to cut to the chase, the court there held that just because one of the two parties on this side of the V decides either to not show up or to stop with the case, that doesn't mean that the other party, who has interests that are independent of the party that quit, all of a sudden can't proceed with their suit. And I view this idea, this dynamic here, where the county chair didn't even do the things it was allowed to do under the statute, to be very similar to Allstate v. Hayes. And I can see a world where if the Court of Appeals decision is not reversed here, you're going to run into that same problem in these kinds of cases.
Thank you.
Thank you.
You're going to reserve the rest of your time?
May it please the court, Chris Trebilcock on behalf of Appellees. Caring a lot about an issue or being passionate about the results in the application of a statutory scheme does not in and of itself create a legal right, does not create a special injury, or does not demonstrate a substantial interest in a matter sufficient to garner standing under Michigan law. In this case, appellants concede that the statute at issue in Michigan election law does not create a legal right. They do not have a claim under the statute. Rather, they take the position that they have standing, and the only way they have standing is for this court to read into the plain language of the Michigan election law a cause of action for them, or to determine that they have a special injury or a substantial right that is different than the public in general. And like the trial court, and like the Court of Appeals, the answer is that they do not have a special injury. The language is clear in the statute, and the scheme, if you understand how the actual scheme works, there is no implied right. As a matter of fact, I think the plain language in the statutory scheme is clear that it's exclusive to the county chairs of their own party, which apparently they don't trust the county chairs of their own party, which amazes me. Plaintiff's claim stated most favorably is that they have that implied right or substantial interest. However, lack of parity, and remember, it's not equal. What they are asking this court to determine is that parity means equal, even though, and ignore and read out of the statute the qualifying language as near as possible. As near as possible means under that circumstance, right? Because this system is driven and the rights are held not by parties. Remember that.
Does anyone under your interpretation have a right to challenge the lack of partisan parity, or do they just have to accept this is the best we could do and that's parity?
I think what the statute is, I think if an individual, remember, Brother Counsel cited 168.677, a couple of things, and I'll get to your question here in a second, because I think this is an important groundwork to lay before answering the question is, to become an election inspector, it's not just simply a county chair nominates you. You have to fill out an application, the individual, not the county party, not the national party, not the state party, the individual has to do it. And they don't declare party affiliation. Affiliation is not the term. It is preference. So you don't have to be affiliated with the Republican Party or the Democratic Party. You just have to state a preference. And the reason why county chairs play a role in it is a recruitment process. It's to get get more citizens who have a preference for one party or the other to serve as election inspectors, okay? If you apply, if you're an individual that you apply and you stated your preference for one party or the other and you weren't appointed, then you would have standing to challenge why you weren't appointed. But I would say this situation is very similar to the issue that was before this court in Johnson v. Board of Canvassers and the issues that come up when you say, what is the responsibility of the Board of Canvassers? This court has held they have a mandatory responsibility and a mandate that they shall investigate quality of signatures, the number of signatures. But this court, and the legislature has not dictated it, this court can't tell them how to do it. And in this case, the legislature said, the election commissions and the clerks, you have an obligation to appoint appoint as equal as nearly as possible election inspectors. They do that. They have discretion, though, within how they appoint. They have discretion based on what's on the application. They have discretion on who shows up and goes through the training. There is discretion that is built in there by the term as nearly as possible. And that term means under the circumstances, recruitment efforts, jurisdiction, timing.
Counselor, it sounds like you're getting into the merits, which
I was still waiting for an answer. to
Yeah,
my
well, I was,
question,
no,
though.
Well, I would say two things. I understand you're talking about the merits, but to analyze the injury, you have to look at what the claim is. And so I think that goes to the injury. To your answer, to your question, who has standing?
Even if I accept everything you told me,
Yeah.
does anybody get to look to see if there's an abuse of discretion, and who is that?
So I would say that the parity is either the county chair, and that's assuming that there is more. If they don't appoint any Republicans, I think then that you would have a cause of action. But as nearly as possible, that is their discretion. And so it would either be an individual who applied to be an election inspector in that county, or the county chair under the statute. That's who has the interest. Because parity, remember, parity in and of itself isn't the injury or the interest. And that's stated in the election law. Parity is not the injury or the right. It is elections that are administered fair and balanced and secure. That is the interest. In the scheme, their interest, or the appellant's interest, is protected specifically in section, let me see here. 168730, which provides them the specific right, quote, at an election, a political party or an incorporated organization or organized committee of citizens interested in the adoption or defeat of a ballot question being voted for or upon an election, or interested in preserving the purity of elections and in guaranteeing against the abuse of the elective franchise, which is what their stated interest is in their briefs, may designate challengers as provided in this act. They have the right to designate on election day people to go into the polls and watch what the election inspectors are doing, watch what the election workers are doing. And if there's a dispute, if you're in, I mean, this is how it happens, AV counting boards. If you go in there, you see them. They'll have a dispute. Is this an overvote? Is this oval filled in right? They'll have to call over a Republican and a Democratic election inspector, and then the ACLU, the Democratic Party.
But that's obviously different. That's like election day. That's different than in advance challenging the parity requirement, right?
Right, there's a reason the process is exclusive in here. You can't move election day. So, do I have standing in a cause of action if I mail a letter to the clerk 3 days before the election and say, look, you appointed 30 less Republicans, here's another 30, and I go in there 3 days before, and the clerk doesn't do it because the people haven't filled out an application, they haven't gone through the training, and I don't appoint them. Does that give me standing then to come in here and say, well, there's not parity, there's 30 less? And where do you draw the line on parity? Is it the same in Marquette County as it is in Wayne County? Is it the same in Berrien County, Kent County, where there may not be the same number of Republicans or Democrats
So I
available
agree with
or
you.
party preference?
I agree with you. That's getting into the merits. It's a super complicated issue. But do we need to look at that for purposes of standing?
I think when you look at what is the interest or the substantial interest or the risk of injury, you have to look at that. And I'd also say that gets to the point that Justice Kavanaugh raised is, okay, let's say you're right. What is the relief? The relief below, count 1, writ of mandamus. Count 2, writ of mandamus, which requires clear legal duty and a ministerial duty, right? Clear legal right and ministerial duty. Here, there's
But
just...
Michigan standing is, that sounds a lot like federal. We kind of, Lansing schools, I mean, I think we were viewed as sort of this very broad case for standing. Wouldn't that be walking back what Lansing schools says?
No, I don't think so, because if you look at Lansing schools, and there was a lot made in the briefs in the application on the Court of Appeals application of Detroit firefighters. And I think if you look at footnote 5 of Lansing schools, that clarifies that the Court of Appeals was correct in their application and reliance on Detroit firefighters. Footnote 5, and I quote from Justice Kavanaugh's opinion, the former Justice Kavanaugh, though, quote, though the court splintered on how to articulate when standing could be implied from a statutory scheme that does not expressly grant standing in the last major pre-Lee case addressing the issue, Justice Weaver's lead opinion articulated general principles consistent with the historical approach. So according to Lansing schools, that standard articulated by Justice Weaver is what the Court of Appeals relied on. Second, Justice Mallett's statement that the key issue is whether the plaintiff can demonstrate any special right, injury, or zone of interest that deserves the protections of law is consistent with the historical doctrine. Again, I'd point to footnote 20 to answer your question, Justice Welch. Lansing Schools cited Associated Builders for the standard under a declaratory judgment action getting to the special injury, and specifically states, case or controversy, interested party. So you have to identify what is the legal right you're preserving. You can't decide hypothetical issues, and judiciability is an issue to consider. And so if you read those cases, so you take Lansing, it pulls in Associated Builders. Associated Builders cites the 1978 case of Stavers. You look at those cases and Lansing did not totally erase all the considerations of judiciability, hypothetical questions. Those are still here. Now, what the prudential approach, and I think Lansing Schools, again, Justice Kavanaugh, in the summary, is what I'd reply to, which is, if there isn't a explicit legal right, which there isn't in this case, you have to demonstrate. And the question is, if this parity is not enforced, this is the way it was articulated, and Justice Welch, I think you articulated it this way in a recent case. If this parity requirement isn't enforced, is the Republican Party or damaged or injured in any way different than the public as a whole? And the answer is no, because you have to look at what is the purpose of that. The purpose is not parity for parity's sake. The purpose is to make sure, as Brother Counsel said, that at least a Democrat and a Republican are in the polls on Election Day, in the precincts. So if a dispute comes up, there's one on each side to make sure it's not slanted one way or the other. The interest protected is fair, secure elections. And parity, for parity's sake, doesn't protect anything. You have to have, in the statute doesn't say you have to have 100%, which is what they've argued. No, it's as near as possible, okay? And so that's where I say it doesn't go to the merits, but you have to look at those things.
And they're just trying to figure out who gets to get a look to determine whether it truly was as near as possible. But let me ask you a question now.
Yeah.
From the standing perspective, is there any difference? Should we be looking at it any different for a deck action versus a mandamus action?
I do think the courts, and I probably won't do a good job articulating it, I do think there is a slight difference the way the courts have articulated it, but I do think it comes down to, as summarized by Lansing Schools, substantial interest or injury different from the public at large. And I think where Lansing Schools, in my opinion, I think sometimes gets muddled, is the one-sentence reference before the summary where it references the deck action. Because if you don't look at that and you just look at the summary, I think the summary in Lansing Schools where Justice Kavanaugh says in summary and then articulates the standard, in summary, standing historically developed in Michigan to ensure a prudential doctrine, which is careful consideration in each case, a case-by-case analysis. If a party had a cause of action under law, then standing was not an issue, okay? We're out of that bucket. In this case, where a cause of action was not provided at court, the court, in its discretion, would consider whether a litigant had standing based on a special injury or right or substantial interest that would be detrimentally affected in a manner different from the citizenry at large, or because of the statutory scheme, the legislator had intended to confer standing on the litigant. I think if you look at that, start at the back. Does this statute infer standing to the National Republican Party? If it infers standing to the National Republican Party, I don't see why any part, the California Republican Party has an interest in making sure Republicans are represented in the polls in Michigan. Every Republican does, right? So you have to go and look at, is there a special interest or a special injury, unique and different, if there isn't 100% parity, which is not required by the statute, by the way. As long as there's one Republican and one Democrat, the statute is satisfied. You could have 2-to-1, 3-to-1, 4-to-1, 5-to-1. Where do you draw the line?
And not to become too technical, but two people who express a preference at some point in the past. I prefer ours, I prefer D's, right?
Mhm.
Not actual Republicans and Democrats.
I'm sorry, I guess I missed the question.
Well, you made the point that it's the preference. All you have to do at some point in time is express a preference. That preference might change, so at the time you actually get to the election, you say you have at least one Republican and one Democrat.
I apologize. If that's what I stated, that was not, preference is the term, but it's you state your preference when you apply. So
Right.
I can state my preference of the Republican Party today,
Right.
this election. Next election, I can state my preference for the Democratic Party.
Correct.
But then, it's up to the chair of the local party who knows me and says, Trebilcock, you're a Democrat. You can't be a Republican. Look at all the cases you represent the Democratic Party on. They challenge it through the process in the statute. The statute works. The other point I would make,
I get it, and they just want standing, so they want to be able to look at it themselves.
yeah,
We get
and that's
this
not
case.
that's not what the statutory scheme provides in this case. And so I think in this case, as applied to these facts, the Court of Appeals got it right. The trial court got it right. I don't think what the Court of Appeals did is modify or change Lansing schools at all. I think the standard as articulated in Lansing schools is the correct standard. I think there's a little, like I said, I think there's, at least when I read it, I get sometimes, you can get into the arguments, is it a different standard when you look at the deck action standard versus what's articulated for the rest of the claims? But I think ultimately, at the end of the day, the summary stated in Lansing schools is the test for standing. It was correctly applied by the Court of Appeals here, and that's why the application should be denied in this case. Thank you.
Thank you.
Just a couple quick details. So first, subsection 674.2 actually has two mandates. It requires the Board of Election Commissioners to appoint at least one election inspector from each major party and to appoint an equal number, as nearly as possible, of election inspectors in each precinct. So there's actually two mandates there. You have to have at least one from each party, but separate and apart from that, you should do what you can to make sure that there's parity. Also, I have to disagree with Brother Counsel on the political party preference point. Subsection 6772 requires a political party affiliation, as does the Secretary of State's FAQ website, where she says, quote, "You must affiliate with a political party" on her poll worker website. The last piece I have is just, I think it should go without saying that the California Republican Party wouldn't have standing here. At the end of the day, the California Republican Party doesn't have candidates here. It doesn't have members here. It doesn't have a 527 committee here. I think that is a fairly sufficient, there are several limiting principles in that sentence alone. I don't think we have to worry about it.
Can you answer, what would be, if it turned out that there isn't parity as near as possible, what would be your client's unique injury?
If there were not parity,
Right.
well, their unique injury is that now they don't have a sufficient presence in the polls to carry out all of their roles that they're given under state law, to open the polls, to close the polls, to seal the ballot containers, to witness when they're duplicating ballots, to witness when there's curbside voting.
So if there's 1 and 1, but not the parity, you still can't fulfill those roles? Do you have an injury?
Oh, I'm sorry. So you're asking if one of the mandates is satisfied but not the
Yeah,
other?
if you have at least one, but you don't have this parity as near as possible, at
Well-
the end of the day, do you have, but they've satisfied the 1 and 1, do you have an injury?
Without a doubt.
Okay.
Some of these polling places you go to, there's a lot going on there. So how are you in 3 places at one time? What if you need to go step out and take care of a loved one or pick your kid up from school? Also, they typically don't work full days. I mean, a lot of these folks are retired. The polls open at 7 a.m., they close at 8 p.m. They work in shifts. So I think my assumption is that the reason why they didn't stop at one each is because it's just not practical. You have to have a roster of people to put, this is a huge undertaking. That they
I don't
have
want to
put on.
drag it on. I got a fact question that might have nothing to do with the legal issues presented, but do you know whether both parties or your client has an organization in every county in Michigan?
Not right now, I do not, but I do know that from time to time, my understanding is that there may not be an organization in some counties. I can't speak to what's happening right now.
And so under your opposing counsel's perspective, in those counties, too bad.
Individuals can bring it, but there's no county chair to bring it.
If that's their theory, that's even one more step removed from the current issues that the county chair would have in enforcing the mandate, separate from the party doing so.
Okay, thanks.
Thank you.
Thank you both. The case will be submitted and the court is adjourned.